Welcome back as we continue with the second part of offer and the two cases that I raised earlier. Now in this segment we will look at the contrasting cases of Storer and Gibson, and what we will also do is to consider further the situations which are distinct from an offer and which amount to an invitation to treat. Now before we consider the case, again I will remind you that you should go to your source materials in order to ensure that you know what it is you are dealing with. Source materials will be the cases, and they will of course be any academic commentary. Now then, let's return to Storer and Gibson. In Storer and Manchester City Council, Mr. Storer received a letter from the council's representative, and the letter said, "I understand you wish to purchase your council house, and so we enclose the agreement for sale. If you sign the agreement and return it to me, I will send you the agreement signed on behalf of the corporation," meaning of course the council. "In exchange, we will ensure that you get the agreement." Now Mr. Storer signed and returned the council's standard form agreement for sale before control of the council changed from the Conservatives to the Labour government. Now, the council sought to argue that this did not amount to an offer, but the court disagreed, as the firm tone of the letter to Mr. Storer indicated otherwise. What the case of Storer shows us is that if there is a clear willingness to be bound by the communication, then that will amount to an offer. Now, consider for a moment, what if the council's letter wasn't so clear? What if the council's letter had instead said, "The council may be prepared to sell you your council house at X price"? Would that communication have been an offer? Well, that is exactly what the court had to consider in deciding Gibson and Manchester City Council. You see, unfortunately for Mr. Gibson, the communication he had received from the council was not as far along the continuum as that which Mr. Storer had received. Now, as such, although Mr. Gibson received a sympathetic judgment from Lord Denning, Master of the Rolls as he then was, in the Court of Appeal decision, when it got to the House of Lords, in agreeing with the stance taken by Lord Lane in the Court of Appeal, were of the view that the statement "may be prepared to sell" was far too imprecise to warrant a clear willingness to be bound, and as such, the communication to Mr. Gibson was not an offer at all. Now, this therefore brings us to the types of communications which pass between parties who are engaged in contractual negotiations. Examination questions in this area generally tend to require you to consider the status of a particular communication. Now, here is a word of warning. Do not let the examiner tell you what the status of the communication is. Make sure you are working it out for yourself in your discussion. Now, what I mean by that is, don't take the examination question's words at face value or being decisive. So, for example, if the examination question says, "A placed a sign on his car offering the car for sale at £10,000. And then the examination question says, "B accepted A's offer and brought £10,000 to A's house." Now, just because the exam question uses the words offer for A's communication and acceptance for B's communication does not mean that that is decisive as to what it is. That is all part of the exam testing process. Now, notice that I keep using the term communication. That's because you have to consider the actions of the individuals. So if A writes to B, if C posts a letter, if X calls Y on the telephone, if Z emails A, all of these are communications which warrant a discussion as to whether they amount to an offer or not. Okay, so what if a specific communication is not an offer? Well, if a particular communication from one party to another is not sufficient to amount to an offer, it may qualify as what is termed an invitation to treat. Now, the primary difference between an offer and an invitation to treat is intention. The intention on the part of the person initiating the communication. An invitation to treat is distinct from an offer in that all it does is merely invite offers, rather than indicate a willingness to be bound like an offer does. What it allows the party inviting the offers to be able to do is accept or reject an offer which is made to him or her. So if a particular communication only reaches the height of an invitation to treat, it will not have any binding effect in similar fashion to an offer. Now, the types of situations which amount to an invitation to treat include, for example, auctions, displaying of goods for sale, advertisements, tenders, and where, for example, you're merely stating the price. Now let's take them in that order, starting, of course, with auctions. Generally, in an auction, an auctioneer asks for bids. He's not making an offer to sell the goods to the highest bidder. So in the case of Payne and Cave in 1789, the court said that the auctioneer was merely inviting offers from which bidders he can then either accept or reject from that bidder. This rule, of course, is now set out in statute in section 57, subsection 2 of the Sale of Goods Act 1979. And it says this: a sale by auction is complete when the auctioneer announces its completion by the fall of the hammer or in other customary manner. And until the announcement is made, any bidder may retract his bid. But think for a moment. That would be where an auction is what is called with a reserve. Is there a binding promise when the auction is without reserve? That is the question. To clarify that, an auction is where a person bids on an item and the person making the highest bid wins. However, the item may have a reserve price, meaning there is a minimum price that it will not be sold less than. So even if persons are bidding, if the reserve price is not met, there is no sale. But assuming that the reserve price is met or exceeded for that matter, there will be a fully formed contract when the auctioneer's hammer falls. And the case of McManus and Fortescue in 1907 is the authority for that proposition. However, the auction item may be without reserve, meaning there is no minimum price on the item. So whatever the bid for the item, no matter how low it is, that will be an offer. So going back to our question, is there a binding promise when the auction is without reserve? Well, although the position had not been quite clear historically, the recent Court of Appeal decision in 2001 in the case of Barry and Davis, trading as Heathcote Ball and Company, has now made it somewhat clear that there is a binding promise when the auction is without reserve. Now in that case, 2 machines were advertised for sale by auction without reserve. Barry, who was the claimant, was the only bidder, and his bid of £200 for each of the machines fell well short of the commercial value of the machines. Davis, who was the auctioneer, refused to sell the machines to Barry, and he withdrew them from the sale. Now, both the Court of First Instance and the Court of Appeal found that Davis was in breach of contract, and they emphasized that in an auction sale without reserve, it was not open to the auctioneer to reject the highest bid, which was the only bid in this case, simply because it was not high enough. From an objective standpoint, this may seem harsh, especially as the bid was so far below the true value. However, to avoid a situation like that, a seller putting items into auction would certainly be well advised to place a reserve price on the item. That then is the position with auctions. They are invitations to treat, and the bidder makes the offer, which then the auctioneer accepts or rejects with slightly different approaches depending on whether the item is with or without reserve. Now, another distinct situation from offer, amounting to an invitation to treat, is the displaying of goods for sale. Now, whilst on the face of it, a display of goods appears to be an offer for sale, the law has different ideas. Let's start with items displayed in a shop window. Well, again, to the average person, it may appear that the goods displayed in a shop window or on a shop counter with a price clearly marked on it is actually being offered for sale. But again, as budding lawyers, we will see differently, because the cases have firmly established that that is not the case, and that displaying goods in a shop is not an offer to sell those goods, merely inviting a person to offer to buy those goods. The 2 cases on that point, of course, are Pharmaceutical Society of Great Britain and Boots in 1953 and Fisher and Bell in 1960. Now, in both cases, the court was of the view that the offer was made not by the party displaying the goods, but by the buyer offering to purchase them. Interestingly enough, both of these cases had to do with criminal prosecutions, which were brought in respect of the sale of restricted or prohibited articles. So you may want to consider, from an academic standpoint, how you would address this in, say, an essay question, perhaps. There are some American cases which you could draw contrast with. Now, in those cases, what was under consideration was a contract matter, and the conclusions were very different. Now, in 2 of these American cases, firstly, the case of Lasky and Economic Grocery Stores in 1946, the court said that the goods displayed constituted offers, but that the acceptance took place not on the placing of the goods in the basket, as in the English cases, but on the customer presenting them at the cash desk for payment. Now, in the second American case of Sheeskin and Giant Foods Incorporated in 1974, the American court said that acceptance took place before the goods were presented at the cash desk, although the customer could cancel his acceptance before payment if he so wished. It is a matter for you which side of the debate you fall on, but the English law position on display of goods remains, as stated by Fisher and the Boots cases, and that is they are merely invitations to treat, inviting offers. Now, we will pause briefly, and when we come back, we will consider advertisements, tenders, and statements of price, which are far more exciting.